Participants now. Hello, everyone. So I think we're gonna get started. Thank you for coming today. Welcome to the 2020 Intellectual Property Speaker Series. Today's session is Patent and Other Protection Available for Artificial Intelligence Related Inventions. Today's session will be presented by two licensing officers at the TLO here at MIT, Ben Rockney and Danny Dardani.
I think I'll take over from here, Kate. Thanks. Can you hear me okay?
Yes.
Great. So thanks everyone for joining. My name is Dan Dardani and I work at MIT TLO. For those of you not in the immediate MIT community, the Technology Licensing Office is a department at MIT that works with a whole group of constituents, faculty, students, researchers, and others to help with intellectual property issues. That is to say, we are responsible for listening to all of the wonderful things that get done in the context of research at MIT. In many cases, figuring out how to protect those innovations, very often with intellectual property, but ultimately striving to commercialize those innovations, bringing them to the market so that they can reach the public through various channels that we have at our disposal. So part of our remit is educating, and we are very pleased every year to do these IAP sessions where we get to talk to the community about what we feel are some interesting topics in the world that we see. Myself, I've been at the TLO for a hair under 20 years, and I am a licensing officer specializing in mainly software and algorithms and computing, which means that my caseload, my portfolio kind of spans lots of technical disciplines that are very much the topic of today: machine learning, artificial intelligence, quantum cryptography, lots of different things. And I've worked with many of these technologies, worked with patent professionals in many of these areas. And I also do a little bit of teaching on the subject. So I'm hoping to share some of my insights with you all today on this snowy day, if you are in the New England area or Boston area. I'd like to turn it over to my co-presenter and colleague at the TLO, Ben Rockney, to let him introduce himself and then perhaps kick things off.
Thank you, Dan. Yeah, my name is Ben Rockney, and I've been at the TLO for about 7 years. Prior to that, I have a background in leading product development teams, both in large companies and then in a few startups as VP of product development. And I've been at the TLO for 7 years, and it's a fascinating mix of law and business and technology. From a technical point of view, my background is roughly equally split between physics. I have a Ph.D. in physics, but for the last 20 years, I've been much more in the life sciences and medical devices. And it's in medical devices that I overlap with the topic of today's presentation. There's a huge amount of artificial intelligence being applied now, particularly to medical diagnosis and to guiding surgeries and non-invasive procedures. So as Dan said, really pleased to be here. I think this is a really interesting topic. And one thing, I guess each of you both see a chat button and a Q&A button. And if you do wish to ask questions, use the Q&A button instead. And I think you also, as a listener, have the opportunity to upvote particular questions. And Kate will be monitoring those questions, and some we'll save to the end. And with her judgment, she might throw some into the middle of our talks, which we certainly welcome. So again, thank you very much. And let me now share my screen and we'll get started. Kate, are you able to see that?
Yep, we are all set.
Great. Okay, so with that, just the sort of the agenda for the talk today. We'll spend a little bit of time talking about what is AI. And I should mention that there's approximately 100, or I think maybe even close to 150 people signed up. And I would guess in a group that size, the experience and the interest spans the whole waterfront. We're not really aware of which one of you, who of you are experts in AI, or who in you are comfortable with patenting, but this talk will try to like your backgrounds, will try to span the waterfront. So we'll spend just a little bit of time talking about what is AI. Really, the gist of the talk is about patenting with AI. And so the next two sections on challenges and alternatives and some particular examples of AI patents will follow. And then a really interesting, very current topic in the field of artificial intelligence is, who is the inventor when artificial intelligence actually makes the invention? And fortunately, that's recently been resolved. The resolution may not last for centuries, but for the moment, the answer to that is clear. And we'll talk a little bit about a particular case that brought that through the court system. So probably all of us know that AI is a really big deal, and it's getting to be a bigger deal day by day. It's the global gross domestic product is expected to grow by, call it roughly $15 trillion because of AI by 2030. And the GDP, the worldwide GDP, typically grows by a few percentage points per year, but it's expected that 1.2% of extra annual growth in GDP will be coming from AI. And that might not seem like a lot, but just for comparison, here's estimated annual growths in GDP in different time periods for different inventions. And so the projection, both by PricewaterhouseCoopers and McKinsey, is that the impact of AI on the worldwide GDP will be significantly greater than it was for the steam engine or robotics, or even the spread of IT throughout our companies and universities. So it is very, very much a big deal. There are several different technologies that are grouped under artificial intelligence. Machine learning, at least as far as patenting goes, dominates the others. And really it's machine learning, neural nets that we'll be talking about mostly today. The number of different applications for AI, transportation, meaning self-driving cars or ships or trucks or farm tractors. At least as of 2016, we're leading all the other applications of AI in terms of patenting. Telecommunications is also big. This is aiming at making routing of information as efficient as possible over networks, having networks be self-healing. So really sort of in the intelligence guiding of data flowing through our telecommunications network is a very big area. And then you get down into lesser areas, human-computer interface and personal devices, security, and my interest, life and medical sciences. So we won't get into these applications much today. We'll really be talking about patenting more in a generic sense. But again, we will be limiting most of our discussion, if not all, to machine learning or neural nets.
Hey, Ben, I'm just going to add something for the audience to recognize. If we look at this graph on the right, I think one of the things that's going to jump out is this kind of steep curve that begins in the 2000s. As many of you probably know, AI as a concept has been around for 50 or 60 years, particularly those in the MIT community know for a fact that a lot of the early workings in AI started at MIT in sort of the basis and predecessors of, the computer science artificial intelligence lab. So as a concept, artificial intelligence is quite old. What has changed to sort of account for this exponential growth starting in the late 90s and continuing on to today? And I think clearly the answer is the confluence of, processing power becoming so ubiquitous and relevant, accessible in our pockets, so to speak, plus massive troves of data to now apply some of these pattern matching techniques to. So something we have to remember is, we can talk about artificial intelligence in a number of different ways, and we're going to get into it later on in the talk when we talk about what it means for potentially AI to be an inventor. But we have to sort of separate the sort of categories. What we're talking about right now is more statistical pattern matching, machine learning types of techniques, which floundered throughout much of the 70s, 80s, and early 90s because they were waiting for computing and data techniques to catch up. And that's what we're kind of living through right now, which I think accounts for the explosion that we're seeing at the patent office and obviously in all the applications that AI machine learning is being applied to.
Yeah, thank you, Dan. So speaking of the explosion of patents, this is a chart provided by the World Intellectual Property Organization. That's sort of the group that oversees the or operates because of the Patent Cooperation Treaty, the PCT. So sort of involved in all of the filing of the standardization of patenting procedures throughout the world. And they've summarized, at least as of 2019, the number of issued patents from a number of academic laboratories as well as national laboratories. And these are grouped by country, and clearly China is way ahead in the issuing, getting patents issued in the field of AI. Amazingly, the Republic of Korea leads the United States, really surprising, but they are obviously putting a huge emphasis into artificial intelligence. Within the US, I just want to point out the University of California is ahead of MIT, but the University of California has about a dozen different campuses, whereas MIT is only one. If you were to look at any individual University of California campus, we would be ahead. And just as an aside, the great majority of this bar attributed to the Massachusetts Institute of Technology can be attributed to Dan Dardani, my co-speaker today, who's really been leading the charge on this historically. And the TLO, along with sort of this growth in AI, we've recently beefed up our coverage of software and computer science and AI in particular. And so that load is being spread. But Dan, at least in the early years, has a lot to do with Massachusetts Institute of Technology having such a prominent position. So just briefly, and I am most definitely not in any sense an expert in machine learning, but I think it's important to just understand the basics of machine learning, make sure everybody is on that page, because we will be talking about what aspects of machine learning are patentable and what aspects are the most fruitful areas to pursue for patenting. And so the general course of machine learning is that we feed raw data into the machine learning element. Typically, there's some pre-processing that might extract from the raw data a higher level of abstraction. In other words, we pre-process into features. I'll give a trivial example of that in a moment. And then typically the pre-processed features are fed into a neural net. And the neural net consists of a series of layers, the input layer and the output layer, and in between a certain number of hidden layers. And for image recognition, it's usually considered roughly eight hidden layers are required to do image recognition. For speech processing, for speech recognition, translation, there can be many tens of numbers of these hidden layers. But each layer has a series of nodes with one piece of data being applied to each of the input nodes. And then every node in every layer is able to speak to every other node in its adjoining layers or adjacent layers. And so there's a vast number of interconnections among these hidden layers. And finally, what comes out is hopefully correct output out of the output layer. And sort of the sequence of creating an artificial intelligence, some sort of a structure that is able to take in raw data and make decisions. We train the AI, we train the neural net with data. Once we have shown that, we do that by showing the neural net some sort of known input and telling it what the correct output would be. And there are mathematical techniques for adjusting the coefficients of each of these connections. In other words, the weighting of each of these connections among the nodes. And so you look for a whole series of coefficients, weighting coefficients for every one of these nodal interconnections. And you look for one that optimizes with the training data so that you feed this net 50,000 training images and you adjust the coefficients so that it gets the right answer 50,000 times. And then you verify that with new data, so data that the net's not been trained on. And once that's sort of ready to go, you release this into the world. And often you can, so you use it with real world data. So that might be a radiograph from a human patient. Often there's additional feedback from humans that are sort of looking over the output of the neural net and saying, yeah, that's right, or that's not right. And so often there's continual feedback over the process that changes the coefficients and makes the net smarter and smarter over time. And so as the net goes out into the world and takes its place, it's continuing to learn from real world data. And by the way, this is one of the challenges with medical devices, because medical devices are approved by the FDA, and then they're not supposed to change without a very formal revision process that requires new approval from the FDA. And so the FDA has, in fact, created sort of a structure of how neural nets will continue to be able to evolve without requiring a new FDA approval step with every single change of coefficient. But that's definitely a challenge in the world of medical devices. And just one other thing to note is that as you look at what's being passed from hidden layer 1 to hidden layer 2 to hidden layer 3, typically each one of these layers represents another higher level of abstraction, another higher level of sort of coalescing the data and human knowledge that goes into the training. And so things start to become sort of more recognizable, for example, as an image, or not just an image, but a subject of an image as you move up these layers. But anyway, that, once the coefficients are set and once the device is reached out into the real world, you hope that it's making correct recognitions. And so, for example, if we want to recognize the image of a blueberry muffin, if we want to be working in a bakery and sorting muffins between whether they're blueberry or raspberry or chocolate chip, we start by taking a picture and digitizing the image of the blueberry muffin, breaking it into pixels, just like people have been doing since the early 80s. Those pixels are fed into a neural net. A lot of training data is applied with human feedback. And then hopefully what comes out at the end is a correct diagnosis that this in fact is a muffin. On the other hand, as you look at that muffin on the left, it does have sort of a kind of a look of a face to it. And so probably sometimes the neural net will announce that this is a puppy. And why do I say it's a puppy? Those of you who might be practicing in the world of AI know that there's been a whole series of really fascinating images of puppies versus real world objects. And they often can look very, very similar. And so in many ways, a blueberry muffin looks like a Chihuahua face. Now, if you were discovered that your AI was having difficulty recognizing Chihuahua faces versus blueberry muffins, maybe you wouldn't feed raw image data of the blueberry muffin to your neural net. Maybe you do some pre-processing. So analyze the blueberries in the muffin and the eyes and the nose and the puppies. And so just as a simple sort of trivial example, how many? If the blueberry muffin is scattered with 7 or 8 blueberries, it's probably not a puppy. Puppies typically have 2 eyes and a black nose. So you might just count how many of these sort of black or dark blue objects are there. How circular are they? Blueberries tend to be more distorted by the cooking. Eyes tend to be more circular. How equilateral is a pattern between the two eyes and the nose? Assuming the puppy is looking straight into the camera, the eyes and the nose form sort of an equilateral triangle. So you might have a metric on how equilateral the 3 major features of the blueberry muffin are. How uniform, if you look at the blueberry muffin, the blueberries tend to be sort of mottled and distorted, whereas the eyes are circular and uniform, except that they have a specular spot, a reflection right in the center. So you may try to recognize the difference in a blueberry muffin and a Chihuahua simply by feeding in raw image data and training it. But more likely you would want to do some pre-processing and feed the metrics arising out of these various pre-processing features into the neural net. And just, it's worth pausing just for a moment. It is amazing what AI can do. And we really believe that in a few years, there will be fully automated self-driving cars, which is a very, very difficult challenge, but AI is just growing by leaps and bounds. And so it is amazing what is being done with AI now. But I think it's also worthwhile just keeping a perspective on how a typical neural net compares to the human brain. So brains have 200 billion neurons, and there's several hundred trillion synapses. So each neuron apparently has on the order of 1,000 different connections to other node points, other neurons around it. This represents about 2.5 million gigabytes, 2.5 petabytes of storage in the human brain. Whereas a neural net has about 1,000 nodes per layer, which results in each node being connected to the other, to every other node on the adjacent layers, results in 1 million connections per layer. And again, 10 hidden layers might be enough for image recognition. 100 hidden layers may be necessary for speech recognition. But even taking 100 hidden layers with 1 million connections per layer, you still only have 100 million synapses. So approximately 1 million fewer synapses in a very sophisticated neural net versus the human brain, and only a very small fraction of storage. So it is remarkable what AI is doing, but it's also extremely remarkable what the human brain can do, often without training. So for example, this is thanks to a woman by the name of Karen Zak, who has just posted all sorts of interesting contrasting images on the internet. For example, bagels and puppies look a lot alike. Or Shar-Pei puppies look a whole lot like rolls of towels. And Afghan puppies or dogs look a whole lot like Saruman. Now, I show these examples just to say that every one of you can immediately look at these images and recognize which is a living thing and which is a roll of towels or a puppy or a wizard. And amazing what our minds can do with really no training specific to specific images. So AI still has a long way to go, and I'm sure will never match the human brain in some areas, certainly will exceed it in others. So that's just a little bit about what machine learning or neural nets are. And now the question with sort of the topic of the talk is, how do we go about patenting this sort of thing? Do we try to patent the machine learning classifier, the neural net at the center, just as a black box? That possibly might have been possible once. That's becoming pretty much impossible now because the patent application has to be enabling. It has to teach the reader how to replicate the invention that's in the patent. So patenting the classifier as a black box is not such a great idea, but maybe this classifier could be structured differently. And we'll show you an example of a patent application indeed that talks about modifying the connections between the node layers. Again, that's probably getting to be tougher and tougher to mine just because so many people have created so many different structures of these neural nets. A lot of the ideas and the patents that we see, or the patent applications that we file, I should say, really fall into this category of the pre-processing that's applied to the data in order to already raise the sort of level of abstraction of the data that's fed to the neural net. So this is a very common strategy to sort of focus on these features and get patent protection around that. And there are also a lot of patents that just patent the entire system. And we'll talk about some of the challenges in doing all of these approaches here in a moment. But we do, in fact, see patent applications and issued patents that cover different aspects of this typical chain of data as it flows through an AI entity. So specifically, some of the challenges in patenting AI inventions, a lot of them go back to a very substantial Supreme Court decision, which is shortened to be known as Alice. It was actually Alice versus CLS Bank. This was a decision by the Supreme Court, probably 12 to 15 years ago. Dan, you might know the exact date of Alice, but it says that this is a ruling by the Supreme Court saying that the claims in a patent may not be directed to a judicial exception. A judicial exception is sort of a fancy term for something that you're not allowed to patent. And traditionally, laws of nature, natural phenomena, and abstract ideas have not been allowed to fall under patent. So natural phenomena, one is not able to patent the law of physics, One is not able to patent a gene because it's naturally occurring, nor is one able to patent abstract ideas. And it was the abstract ideas that the Supreme Court really honed in on and really increased the bar for getting software patents through the patent office. And for a number of years after the Alice decision, it was pretty well regarded or pretty well assumed that an algorithm or software isn't patentable. And the strategy in writing patents in the field of AI or software, ever since that Alice decision, has been to increasingly emphasize the tangible nature of an invention. So really tie the artificial intelligence or the software to a very concrete output, a movement of a switch on a machine that will change the speed of rotation, or something that will change the temperature of a manufacturing process. And there's been mixed and inconsistent success doing that. It has always been kind of a throw of the dice, whether claims, even those tied to tangible outputs, has always been a throw of the dice as to whether a patent examiner will allow that or not. There was an improvement, very much an improvement in 2019 in the ability to patent software, where the US Patent Office, this is not the Supreme Court, but the US Patent Office in 2019 revised the guidelines that they give their own patent examiners. So these are the people that are looking at patent applications and deciding whether to reject them or allow them. And the USPTO revised its guidance to say that a claim that recites a judicial exception, remember a judicial exception in principle, something that is not patentable, it's not directed to the judicial exception if the judicial exception is integrated into a practical application of the judicial exception. In other words, just what I said before, if you can really tie the output of the invention to something practical and tangible, you'll have a pretty good success of having the patent office not disqualify it because it's abstract or it's software. This has really changed the game. We really did see a step function increase in the ability to get software and algorithms allowed by the patent office. But it's not necessarily a stable situation. This is guidance given by the US Patent Office, but the US Patent Office is obligated to follow the law, and it's the Supreme Court or the courts below it to determine what the law means. And so the Alice decision still stands. The Patent Office has just chosen to apply a more lenient standard to their decisions. And it could very well be that there will be a case brought against a patent holder where the person bringing the case wants to infringe the patent, they want to invalidate the patent. And so a case may work its way up through the courts all the way to the Supreme Court, where the Supreme Court will have another shot at determining whether software and abstract ideas are patentable if tied to something tangible or not. So that's very much a kind of watch and see. But at the moment, we're in a fairly favorable phase for getting software and abstract ideas through the patent office. And this all plays directly to the ability to get artificial intelligence inventions through the patent office. Typically these have a high level of abstraction, sometimes sort of a black box associated with them. And they really are rising and falling on the sort of the rigor with which the US Patent Office applies the Alice decision to their patenting decisions.
So Ben and Danny, we had a question related to that point. The question was, do you think that there is a quantitative correlation between patent issuance and economic viability or traction? And I say it may be related because tying inventions to sort of something tangible in that sense might be sort of thought of as related.
I could take a stab at that, Kate. It's no secret that patents exist to help drive economic conditions. They're inextricably linked. We like to think of them as different silos, but all intellectual property vest in being an engine to drive, if you go by the Constitution, progress of science and the useful arts, which was sort of 18th century code for, innovations and, economics. So I would argue, yes, there is a correlation, quantitative or otherwise, of how intellectual property and the number of patents being offered are tied to the sort of economic output or engine. Some would argue whether or not there is an inverse relationship where the tail wags the dog, and argue that we need strong intellectual property laws in fields like software, where Alice has kind of weakened and made things less predictable, and artificial intelligence in other areas, in order to drive their economic significance, as per our first slide, talking about the GDP growth and sort of benefits for the world economies. I think there's different scholarly opinions as to whether the patents force the economics, or whether the economics kind of offer allowances for the patent office to relax its interpretations, but that's probably a topic for a different IAP.
Thank you.
Thank you, Dan. So that is just a very brief view of what the situation for patenting software and AI inventions in the US are. The situation in Europe has traditionally been a little bit easier than the United States, but now with this new guidance from the Patent Office, really Europe and the United States are pretty much in alignment. Like the United States, in Europe, there are not, the situation is very similar, but the words used are sometimes different. So in the United States, there are judicial exceptions. In Europe, they're called exclusions from subject matter that is eligible for a patent, but exclusions in addition to the natural laws, and like in the US, includes programs for computers and mathematical methods. So we would call that software and algorithms in the United States. And so in Europe, those are technically excluded from being patented. But the EPO, like the US, though they were a little earlier, issued new guidelines affecting patenting for artificial intelligence and machine learning. And so I'll just read their quote. "It must be taken into account whether the method in the context of the invention serves a technical purpose." And then among the sort of examples of a technical purpose, very similar to the United States, controlling a specific manufacturing process, for example, or a medical instrument, an X-ray apparatus, or steel cooling process. So if your software or your AI controls a very specific, tangible system or process and controls it in a very identifiable way, you probably can get a software or machine learning patent through the European Patent Office. Another example, providing a medical diagnosis by an automated system that is making physiological measurements. Interestingly, in Europe, as an aside, you cannot patent any therapeutic inventions. You can't patent a lot of medical instruments that are specifically aimed at providing human therapy. You can't patent the method. Sometimes you can patent the system or the apparatus. But that was really just an aside. But as far as software and AI goes, again, just as in the US, it's important to tie the output to something tangible. But there are other challenges related to patenting AI. So we've just talked about patentable subject matter, meaning software and algorithms. But there's other challenges somewhat unique to AI. Novelty, for example. So something is not patentable if it's been clearly already described in the literature, either in patent literature or publications or books, or for an object for sale. And a lot of AI inventions now use a standard neural net, a neural net that's available in software or in hardware. And there's a lot of standard configurations of these neural nets. And so some of the novelty challenges around the neural net are increasing. But what is novel in an AI invention typically is no longer the net itself, but it may be sort of like the pre-processing or something about the entire system. but it's also important that an invention not be obvious. And this is a higher bar even than novelty. I mean, it's getting to be the point where really any question that you might come up with, you can it's obvious that you could apply artificial learning and training to it. And so back in the early days, it might have been patentable if you wanted to apply artificial intelligence to looking at a tree bark and to telling whether the tree had chestnut blight. That might have been patentable in the early days. I don't know if there was ever any patent related to that sort of subject, but you'd have trouble getting an artificial intelligence system aiming at diagnosing chestnut blight through the patent office now. It's obvious that you can take images of any kind, train them with a human and a neural net, and then set the neural net loose to perform a diagnosis. So at this point, even if the idea is novel, like diagnosing chestnut blight, it's probably obvious. A patent examiner would consider it to be obvious. So again, sort of the fence, the circle is getting smaller, the fence is narrowing for what is considered patentable and not obvious. Enablement, from the very beginning, from the Patent Act of 1790, the idea of a patent was that in exchange for the inventor explaining to the world how to do something, how to practice an invention, the government would give that inventor 17 or 20-year lifetime of monopoly. But the enablement is important. You have to teach, the reader of a patent has to be able to learn how to practice that. And so, of course, a lot of what goes into an AI system is in fact hidden. It's hidden in the black box of the neural net. It's very much internal and very much hard to be discovered from the outside. And so enablement rejections in an artificial intelligence application are not uncommon. And then as a patent holder, it's also always important to know if you can tell if a competitor is in fact infringing. And again, sort of the black box idea, it can be very difficult to know how a competing AI system is actually making its decisions. And so a patent in the field of AI sometimes is less valuable than it is for an automobile transmission, for example, where you can take the transmission apart and see how the gears connect. And a question we'll come to right at the end of this talk is, who owns an AI invention? Many times, even to the researcher, it's very much a black box as to how the neural net is arriving at its decision. There's probably a million coefficients in there, and there's nothing intuitive about those coefficients. And so who invented that? We'll talk about this. Did the person who put the neural net together and fed it data, are they the inventor? Or is the neural net itself the inventor? Who is the inventor? And both the good and the bad, in software and in AI, there's definitely a culture of sharing. Open source, rapid publication, rapid changes, people taking modules developed by others and making modifications and through open source. So it's sometimes very difficult for patent applications to kind of keep up with what's going on in the research community. And it's also questionable whether a patent issued in 2022 is still going to have much value in 2023 or 2024. So there are some pretty unique challenges in patenting these sort of semi-abstract AI inventions.
And I just wanted to add one more thing.
Right.
And it has to kind of go back to what you were talking about in section 112, enablement. One of the things that we are also seeing is that the very nature of a machine learning innovation is that it kind of will be tweaked, it will evolve, it will grow the more data it has access to lend its sort of pattern matching skill set on. And so those coefficients and those weightings might wind up changing in order to adapt to increasing levels of sophisticated data, which have obviously increased the resolution and precision of the output, but might fundamentally change the claims of the patent that you initially filed on. So it's difficult from an enabling point of view to capture both sort of the specificity of what it is you claim in your invention and still try and leave it vague enough to accommodate this growth or this evolution. And a strategy that lots of patent professionals have deployed in the past is to try and be as vague as possible or use language that covers as much patentable real estate as possible without committing to real specifics. And of course, that's exactly the kind of creative patent drafting that in part led to the pendulum swing for the Supreme Court and others to start coming down on these patents, which were increasingly being seen as gathering more and more power against the market. Software patent, everyone would be infringing in a sense if we were to go by the standard language that some of these patents were getting issued with. And so the AI is not immune to this. Machine learning patents are not immune to this. If you try and accommodate how it plans to grow and evolve by becoming less precise in your language, you skirt dangerously on not enabling your application, specifying it enough to get over that hurdle, and also butting against the sort of Alice abstract idea issue. So I think for both of those reasons, what we find is patents that were filed on a model, and that model then changed 4 years later, as it should, based on sort of the growth of the research, led us to conclude that we couldn't keep filing patents on every single permutation of how a model would evolve over time.
Yeah, which brings us to our next topic, is other than patenting, what are ways of protecting AI inventions? And so this first point kind of summarizes what Dan and I have been saying over the last few slides, is that machine learning implementation can be phenomenally valuable, phenomenally successful, but it may be hard to find things that are patentable in it. There's a lot of use of commercial machine learning packages, and so the novelty has gone there. It may be obvious if you want to have an AI system that predicts an imminent heart attack, it's kind of obvious you probably want to measure body temperature, heart rate, blood pressure, oxygen level of the blood. So an AI system that monitors a human and predicts that he or she is about to have a heart attack, phenomenally valuable, perhaps phenomenally successful if such a thing existed, commercially successful. Yet it may use a commercial machine learning package. It may use fairly obvious physiological input. And it could well be that it's the method of training or the method of pre-processing the data that is really the secret sauce to the invention. And that may be something that you don't want to reveal in a patent application. You may want to sort of keep that protected as a trade secret, as know-how. So it's not always easy to get a patent on a very, very successful and powerful AI implementation. And one thing that both Dan and I are seeing more and more and more is that the aspect in a machine learning or AI implementation that is of most value may not be the idea of a patent. It may not be the idea of any specific aspect of the machine learning process, but it's actually the data that is fed in. And data, it's no secret, data is becoming incredibly valuable. It's becoming incredibly larger in scope. And it can be very, very difficult for a competitor to get access to the same sort of data that you have if you're the first mover. Think of the data that Google, Facebook, or Amazon are able to aggregate from all of the interaction that consumers have with these companies on many, many different fronts. Very difficult for a competitor, other than maybe the big 5 or 6 tech companies, to replicate. Human medical data is extremely valuable, often costs a lot of money to acquire, and it's a lot of effort and time required to get permission, informed consent from a cohort of humans on whom testing will take place. And then, of course, data can be just distributed all over the world in wildly different formats. And so if you can put together a big body of coherent data, it has phenomenal value, and particularly in the field of training machine learning algorithms. So something that we're seeing increasingly is the data is being protected as a trade secret rather than a patent being written. It's not to say that patents aren't valuable and shouldn't be written, but there's sort of an increasing recognition that data is really the valuable aspect here. And so, among the pros, you're not teaching anything to your competitors, whereas when you write a patent application, you're required to have a specification that teaches the world how to perform your invention. With data protected as a trade secret, you're not teaching nothing to the competitors, and you have an immediate competitive advantage. You probably can collect the data and change the data faster than you can get a patent. Cons are, it may be difficult to collect data, but there's no legal barrier preventing your competitors from doing that. It's an economic barrier rather than a legal barrier. And it'll be interesting to see how venture capitalists respond in startups to the assertion that what is valuable in this company is our data, or it is our know-how and how we process the data. One of the first questions out of VCs' mouths when they listen to a presentation is, what's your sustainable competitive advantage? And they want to hear that you have patents. So they are certainly less familiar with the idea of having copyrighted software or know-how or data, and it'll be interesting to see how they respond to that. And does the owner really own the data? Obviously, there's privacy concerns. That's front and center as we discover somewhat belatedly and alarmedly how much data the big tech companies have on each of us. Medical data often is actually not owned by, well, it's often owned by the hospitals where the medical data was collected, but there are restrictions in the informed consent forms. There's often restrictions against using the data for commercial purposes. It's intended to be used for research only. And so there's kind of an evolution in collecting human data of making sure that the owner of the data really has full use of the data and can use the data for commercial purposes. And this is something that Dan is very familiar with. It's increasingly the research code is being licensed under a copyright license, which in effect is know-how, and it gives a great head start, provides a short-term competitive advantage, but the advantage does fade over time. And Dan, maybe you want to comment on this, but I think our office is starting to use, or has been using equity-only licenses for software and copyright licenses. Is that true?
That's true. And this kind of gets filed in the category of alternatives to patenting. As we said, one of the issues, I think, as we've been trying to communicate is, patenting may not be the easiest road ahead for machine learning or sort of an AI innovation, but there are some of these other things that we can kind of take advantage of. The analogy I like to use is we're all familiar with apps now. We all have smartphones that run lots of apps. You might even be so inclined to think of, oh, there ought to be an app to do X. Just the fact that there's someone that wants to create an app to do some kind of function and it happens to run on your smartphone doesn't automatically guarantee you that you'll have a patent just because you've had this epiphany about what this app can do that maybe even doesn't exist. Simply because really what you're doing or what you're talking about is fairly routine features being performed in a computing environment. And just like your smartphone can have lots of off-the-shelf app tools to help you build it, the fact that you might be first to apply it to a unique feature set doesn't automatically entitle you to a patent. Quite the oppositely, you're very likely to encounter a lot of roadblocks on your road to patenting. But that doesn't mean that the code that implements your concept is valueless. Your app can still perform, maybe even commercially be successful in getting lots of folks to download it without having the patent, simply because it is useful. And in that sense, we license code that implements machine learning techniques in AI, even if we are willing to forego sort of protection of the underlying model for myriad reasons, such as it's being freely shared among researchers. It's likely to evolve so quickly that sort of putting down a stake in the ground today is not going to be very useful, 5 or 10 years down the road. And so in order to try and facilitate what we feel is an interesting modality of commercialization is how can we get this software out to the world? And we've already talked about a couple of examples like open source, which are direct forms of technology transfer, certainly very popular and very useful. But for some that want to take a more proprietary sort of road to commercializing their innovations through code, we've looked at equity-only licenses. So these are, very simple, not necessarily heavily negotiated, for a sort of standard amount of equity, no royalties, no cash. And you can sort of come into the licensing office, request one of these licenses if you have a qualifying piece of code, again, no patent. And then, we essentially get you set up and get you out as quickly as you've come in, and you are able to then bring your innovation to the world, hopefully successfully.
Right, and that's, as Dan said, that's in contrast to a typical license from the licensing office, which might have fees which go on for the entire life of the patent for 17 years. Royalties on sales, there could be milestone fees, there could be annual fees just to sort of maintain the license. But this equity-only license is a sort of a one-time upfront. If you then go off and have great success, MIT will share in that success through our equity. If you instead struggle, at least you're not giving more money to MIT to sort of follow up on a product that's not successful. So it's very much a sort of a shift in the philosophy of a license that our software folks are using quite a bit. So we've talked about some of the challenges to patenting. We've talked about alternatives to patenting, but let's say you really do want to go forward and you really do want to patent a machine learning implementation. And so Dan and I thought about, just in the interest of time, just coming up with a couple of examples of patents that MIT has filed that have issued that are in the field of machine learning or artificial intelligence. And so we talked about what are the various things that you may think about patenting along this chain. And the specific example, two specific examples. One we chose, this one goes back quite a ways, back to 2009. And this is an issued patent owned by MIT that actually does patent the structure of the neural net. And so as you remember, the classic structure is a whole series of layers. Each layer, and each node in each layer is connected to each node in every other layer above it and every other layer below it. But it's a very, very strict hierarchical structure that typically is sort of following a flow of abstraction, increasingly abstract representation of the data as the data flows in these drawings from the left to the right. This patent, when we look at the claims, it's talking about an image recognition system, but the hierarchy of layers is looser. And so the hierarchy allows bypass routes between layers. So layer 4, instead of just communicating with layer 5, layer 4 can communicate with layer 6 or layer 7 or layer 8, resulting the patent claims in increased selectivity and sort of a faster production of the abstracted data than could be done with a strict, layer n feeds layer n+1, which feeds layer n+2. And so this is an issued patent. It is aiming to sort of emulate what happens in the visual cortex of the human brain, but it is a unique structure of the neural net. Another patent application, which is issued and has in fact been licensed to an MIT spinout, a company by the name of NQ Medical, is a technology aimed at monitoring a user's keystrokes on a keyboard and detecting the advancement of a neurological disease, for example, Parkinson's disease. And so this again is an issued patent that has been licensed to a company that's off to a great start, NQ Medical, here in the Cambridge Innovation Center. And as I said, it's analyzing, this is a figure from the patent, it's analyzing keystrokes that a user places on their keyboard. And so, as a key is struck, the key goes down, the key goes up, another key goes down, another key goes up, and this goes on over time. They pre-process the data rather than just feeding these raw times into the neural net. They pre-process the data by calculating a number of different intervals. And it's these different intervals that are then fed into the neural net. And so this is really a patent. It covers the pre-processing, but it's really as well covering the entire system of using this entire keystroke analysis system to detect human disease. And so determines a plurality of biosignatures. The biosignatures are those various latency and up and down times of keystrokes. And then they determine for the plurality of biosignatures, of the plurality of distributions of the intervals, they feed that into the neural net. And then hopefully what comes out is a characterization of the user's motor function, storing an indication that the user may have that condition, such as Parkinson's disease. So various portions of the claims of this patent claim that pre-processing and the collection of those particular sort of abstracted parameters, but then there's also a claim on the entire method as a method of determining whether a person is suffering from Parkinson's. Parkinson's is mentioned in some of the later claims, but really any neurological disease that affects your ability to type, in theory, could be characterized with a system. So that's an overview of patenting, of what an AI system is, how various strategies you can go to either patent it or protect it, some examples of some AI patents. But as I said, we're coming to the fourth topic. As I said at the beginning, a very interesting topic of current discussion in the field of AI is who is the inventor when AI invents. And AI inventions over time are becoming more and more abstract, more and more all-encompassing. In the old days, it might have just been an image recognition that can recognize a muffin or a puppy. But we're now entering the realm where artificial intelligence systems are actually able to scan the patent literature, scan the scientific literature, and come up with their own inventions. And so the question is, who is the inventor in that case? Is it the person that programmed the system? Or the researcher, typically not the coder, but maybe the PI who's working with that coder to solve the problem? Could be the entity or the organization that collected the data that goes into the training, or is it the AI entity itself? And so there was a very, very interesting recent case that was settled in the US court system where there is a device called DABUS or DABUS, I don't know how it's pronounced, but it is a creativity engine, it's what it's called. And DABUS stands for Device for Autonomous Bootstrapping of Unified Sentience. And this is an artificial intelligence system, as I said, that can actually span, kind of look through existing inventions and try to find new ones based on that. And it does that by coming up with an invention and playing off against it in an adversarial network approach. And DABUS has actually come up with two different inventions. They're both kind of dumb, actually, but they truly are inventions. One is an improved interlocking food container where the shape of the container is fractal based, and it uses fractals which are able to interlock with the neighboring containers with no wasted space. I mean, not fractal, but obviously a cubical food container interacts very favorably with its neighbors with no wasted space. Tetrahedral, like the old milk Tetra Pak containers, can stack with no wasted space. But this was perhaps a way to make the food containers stick together and interlock, but again, with no wasted space. And there's also a flashing light that mimics neural activity so that it's more noticeable. So for example, we're discovering that different frequencies of light interact with a user's brain in certain ways. It's been known that certain frequencies of flashing light can induce people that suffer from epilepsy to go into a seizure, but there's other patterns of light that are less, that are not less damaging, less harmful. MIT is doing a lot of research at McGovern and Pecauer institutes in different patterns of light or sound that can improve the ability of the human to store memory or to slow down the progress of Alzheimer's. And so there are different frequencies of light that may make a signal more noticeable to a human. And that's one of the inventions that Davis came up with. So the question is Davis, is the actual AI entity the inventor? And if not, who is? And so the creator of Davis, Stephen Thaler, filed 2 patent applications in the summer of 2019. And in the application data sheet, so this is the data sheet that goes with every patent application that says, you know, who are the inventors, who did the inventors assign their work to, who's the patent attorney, various dates, various pieces of prior art. Stephen Thaler identified the inventor not as himself, but as Davis, and stated in the data sheet that the inventions were created by AI through a creativity machine. And he also wrote a fairly long missive accompanying the data sheet, offering the opinion that Congress has never seriously considered the idea of a machine being an inventor. And he, you know, this was a first, and he wants Davis to be credited as the inventor. However, inventorship is not always the most economically important aspect of a patent. What's really important is the ownership. And so those ownership initially follows inventorship, but typically inventors as employees or you know, working on funded research at MIT using MIT facilities, inventors typically have to assign the ownership of their invention. Even though they retain inventorship, they have to assign the ownership to the organization that sponsored them. So Thaler included an assignment of ownership, ostensibly with Davis giving ownership to him, but he signed both signature lines. He signed both as the recipient of the ownership and the donor of the ownership. And so for Davis, he said, Stephen Thaler assigning on behalf of Davis. A little bit humorous, but definitely groundbreaking. But the patent office followed a few months later by sending to Stephen Thaler a notice to file missing parts. Missing parts can be anything. It can be the application fee. It can be figures in the patent. But in this case, they noted the absence of a human inventor and said, you need to file the missing parts being the name of one or more human inventors. So instead of responding to that, he just filed a petition restating his position, again, talking about the deficiency of Congress and recognizing non-human inventors, and asked the USPTO to reconsider and to vacate its notice to file missing parts. Well, not long after that, the US Patent Office denied his request, and they wrote a very nice multi-page reply citing the original Patent Act of 1790 and citing multiple examples of case law that since then, where courts have held that an inventor must be an individual human. And so they basically denied his request to allow Davis to be considered the inventor. Said, you've got to tell us the name of a human. So instead of doing that, Thaler, as a plaintiff, brought suit against the US Patent Office as a defendant. So Stephen Thaler was the plaintiff, the US Patent Office was the defendant, went to the first court that would hear him, the US District Court, Eastern District of Virginia, and made his case that Davis should be allowed to be the inventor. The court quickly, forcefully, and clearly ruled for the Patent Office, saying the plain meaning of an individual, as mentioned in the Patent Act of 1790 and subsequent case law, is a human being. And so for the moment, that is indeed where things stand. AI entities, machine learning implementations cannot be regarded as an inventor. There has to be humans named in the inventorship. Nevertheless, the USPTO does continue to study the question. They've sent out surveys to practitioners in, patent attorneys and the like, just asking for their opinion and soliciting comment from the general public. But today, that is where it stands. The court has ruled that there has to be a human inventor involved. And that may change in some, at some point in the future. It may be as AI continues to be more human-like and get more and more sophisticated. It could be that Congress will amend the Patent Act of 1790 to allow a non-human inventor. But for now, it's very, very clear, very, very settled that, in fact, an AI system cannot be an inventor.
And I just wanted to add a
yeah,
little
go
bit
ahead,
of
Dan.
a
Thank you.
color commentary on this topic. I think the sort of interesting components of this have to do very much with what captures the imagination of the public when we think of artificial intelligence. And of course, we immediately think of sentient intelligence. That is to say, where the computer itself not just passes the Turing test, but actually has its own unique thoughts, maybe even feelings.
Maybe
and,
self-awareness.
And all of the other things that go along with that, as in lore and science fiction. We're not there yet, I would argue. The type of machine learning that we've been talking about thus far in this talk, and really the ones that are driving a lot of the technical innovations in the marketplace, really kind of look more like sophisticated techniques for doing pattern matching, recognition, search, even arguably advanced systems like IBM's Watson and all of those other cool programs that go on to beat grandmasters of chess and Go and win Jeopardy tournaments. At the end of the day, they are still more closely aligned with just algorithms that are able to process information and recognize information much quicker than a human can. We have not necessarily crossed the chasm towards sentience. The rule for inventorship is someone who has conceived of and or reduced to practice the invention. And I guess the question that the courts have specifically addressed is that in their mind, that can only be a human operator or a human agent. And indeed, the laws are written as whomever may invent, a person shall be entitled to a patent unless ... And for those reasons and those reasons alone, they were almost forced to side with this decision. I think what Ben and I are sort of introducing with this last bullet is that might change as the technology evolves to perhaps appear more sentient. And maybe it will take an act of Congress to sort of change the definition slightly in order for the Patent Office to reconsider its position. But what the DABUS invention did, I think, a curious aside, the DABUS invention itself was patented. That is to say, the actual mechanism for the neural network that drives DABUS itself was issued patents.
By Stephen Taylor.
This is the first time that the output of this patented invention has generated what it feels are inventions. And we are now looking at sort of the child of this, I'll call it Frankenstein's monster, although I don't think it is indeed a monster. And what is unique, I think, about DABUS was it was not slavishly honed to give insights into a particular field, as lots of other machine learnings are. They're usually extensions of the experts that are sort of building them. We think of oncologists looking at how to develop pattern recognitions that can find cancer in images perhaps better or as good as a human operator might. These are experts that are honing these techniques. What Thaler did was he had no expertise in the subjects that these inventions would come forth. He trained the neural network to be able to sort of chaotically kind of think about different things and test various paths that could be fruitful, hence the creativity engine. And then through what we call adversarial AI, have a separate agent, a separate neural network that would critique or say these are promising, these other areas are not. And through sort of the antagonistic nature of these agents competing against each other, whatever would prevail might presumably be considered a novel invention in the sense of It was something that was conceived of, not anticipated, but truly conceived of out of the ether and reduced to practice, fulfilling the definition of inventorship. Again, ultimately falls short because of the mundane aspect of how our laws are written, but I think fascinating when we think of kind of the philosophical implications of what that essentially creativity engine is doing. And perhaps, we're just scratching the surface here in terms of what this might lead to, if we fast forward a decade or, 50 years of what's possible. To Ben's earlier point, the human brain certainly has artificial neural networks for the moment, both in terms of scope and in terms of output, but human brains have had a little bit of a head start on the computing field, right? And so if we look at my best estimates, the natural evolution of Homo sapiens, what will our computers be doing with a couple of 100,000 years of technological improvements? So I'll stop there.
Yeah.
Turn it back over.
Yeah, well, those are all good points. In some ways, that adversarial network that Davis used, to sort of push against itself is almost like the sort of training exercise that humans have typically done with neural nets. So it's interesting that there's sort of a higher level of invention that Davis is applying to itself. So it is really a fascinating topic. I will just point out, of course, that what we're talking about here is inventorship, not ownership. Ownership is economically the more important thing, and ownership has really never been in question in this particular case. Stephen Thaler claims to own the creativity engine, the Davis, and claims that he should therefore own the output of Davis, and probably no argument there, but that ownership is so far clear. No AI system has so far tried to claim ownership, and there is no mechanism for a non-human to own property, at least in the United States. So we're not sort of threatening to upset the whole economic system quite yet, but it'll be really interesting to see what happens in 50 or 100 or 100,000 years. So let's see, I think with that, we are done. And I don't know, maybe Kate, if some questions come in that you might like to pose to Dan or myself.
Yeah, there's been a lot of questions in the chat, and I think there's one that we touched on it, or you touched on it sort of just now with the Davis explanation, but just to kind of ask a bit more directly, because I think it's something that's happening commonly in the therapeutic space. So the question is around what happens when an algorithm identifies a novel composition of matter, and the scientists kind of do the work of identifying its usefulness. Can the scientists claim themselves as inventors? We just learned that an AI cannot be named as an inventor on a patent. But yeah, so just kind of interpreting the previous case in that scenario.
Dan, do you want to take it?
I'm happy to. We could both take a stab at it.
Mhm.
I think what the question asks is very much, I'd argue, how things operate probably today. And that is there are lots of teams trying to compete to use tools, whether they just be computers or now we can say AI tools, machine learning tools, to figure out, novel compositions of matter, or, which compounds from a whole database of chemicals might be good targets for drug discovery or for therapeutics. Everyone's looking for the edge to try and figure out how to discover what is the latest and greatest. And if they are lucky enough to do so, they put their name on the patent. And as Ben said, ownership being what trumps inventorship, their company as the assignee of the patent for that novel composition or potential, drug compound. And that's pretty much business as usual. And the patent office would likely not bat an eye over that application, listing those human inventors and their corporate owners as assignee, regardless of the sort of computing tools, machine learning or otherwise, that went into developing it. You can almost argue the humans are taking credit for, the output of their own creativity engines. And that's, I think, been how it's worked forever up until now. I think what we're seeing now is perhaps the precipice of a slightly changing where you can argue there will be engines, autonomous engines that are arguably not being set up or slavishly honed by their expert owners and still coming up with inventions that I think are going to test the waters, as we've talked about with Davis. So I don't see what was described in the question as being controversial. I see that as being likely how things are done now, where, if you set up the mechanism and the means, you essentially claim credit for the output, either as an inventor or owner.
Yeah, I very much agree. Let me see if I can organize my thoughts and have this make sense. But if I paraphrase the question, I think it's, is the human really an inventor here? Have they really done enough work to be credited as the inventor, or was it the machine learning algorithm? And therefore, is it okay to say that the human is an inventor for the purposes of a patent? And I think in some ways the system protects itself. So if there's really no invention in there, if it's just an obvious application of data to a off-the-shelf machine learning implementation, and sort of the whole idea is kind of obvious, then there really isn't a brilliant human contribution there. But the patent office will not allow it as a patent. They'll say that's obvious. So in some sense, well, every patent that goes through the patent office has to convince the examiner that there's an aha moment there, that there's some form of a light bulb went off over somebody's head. And if you don't convince the patent office that a light bulb went off over your head, you're not going to be an inventor, but they're also not going to allow the patent. If they allow the patent, they're going to say, oh, there was some really clever thing there, and it's probably not going to just be the AI engine. It's probably going to be something that the human contributed, something in the pre-processing, something in the structure of the neural net. So I think in some sense, the system kind of protects itself to make sure that when a human is named as an inventor, there really was something inventive. I don't know if that makes sense. But.
So we have another question that I think is a good opportunity to sort of explain assignment and ownership versus an inventor on a patent. And the question is, can there be a group-owned patent? For example, can a hospital own or file a patent on AI?
The answer to that is certainly yes. I mean, again, you need to have some human inventors identified, but a corporation is the typical owner. They're not the inventor. Employees of a corporation or individuals working on their own from their dining room table are the inventors, but you absolutely can have a corporation be the owner of a patent or a group of inventors.
Thank you. So another question, and this is kind of turning into the realm of the ways that you can protect AI that you talked about. So patenting, copyright, maybe a trade secret. So the question is around marketplaces to help buy and sell machine learning algorithms and licenses. I think a starting point would be, what would you expect those to look like? What do they look like if they currently exist in terms of sharing AI technologies?
There are marketplaces that exist for both sharing of machine learning techniques and models. as well as for commercializing. They come in a few different flavors. Of course, there are kind of the general, if you have a model and you're comfortable with others using it, there is the equivalent of like GitHub, where you can, share your models openly and freely with anyone that would like to use them. And those usually have little or no cost in order to do that. There are also marketplaces that do charge a fee, not unlike, let's say, the Apple Store or Google Marketplace, where you'll have access to use certain machine learning engines for a standard fee and apply them. There are also increasingly repositories or marketplaces that will categorize various types of models, various types of machine learning techniques, and post them for corporate users who would like to have their data run in a particular model environment, but are very risk adverse and do not want to openly share or turn over their data. And so in this sense, they're kind of renting the machine learning technique that's being run in a secure environment against, let's say, confidential or proprietary data, so that there is really no worry or concern or even risk that these data sources, might spill over or might be somehow picked through by others. And so this is a really intriguing new model that we've seen, where the aggregators of the machine learning are basically offering services for hire for clients that allow them to run these algorithms in their own sort of private sandboxes. So think if you're a hospital, an insurance provider, and you have very sensitive but confidential data, and you do not want to turn that data over, but keep it sort of behind your own firewall, you'll be able to still use these techniques, even get aggregate information from other users, other insurance companies, other medical categories with their private data. You're just accessing the output and not necessarily learning anything about the data that went into providing that output. And I think that's really a really interesting development of the marketplace of late.
In the same vein of marketplaces, there's a question of how can open source developments work with copyrighted AI? How do those interact?
So I think the key thing that you have to, I think, understand here is open source is not the opposite of copyright. Open source and copyright need each other in order to work. Open source is a license for copyrighted information, and it's the license that provides the openness. So you sometimes hear this term copyleft. What we mean by that is the terms of the license itself are very open and permissive, but they require there being a copyright and copyright law as the skeletal backbone for the open source to exist. So once you get that concept, you'll realize that, open source and copyright can mutually coexist, in fact, require each other to coexist. And open source, again, is just the mechanism, the repository for saying, I don't mind if various constituencies use this in these manners. And it's because that I own a copyright in my creative work, software or otherwise, where I am allowed to make that decision for my work of who I freely wish to provide it to.
So there's a question about, sort of a specific question about neural networks. I'm not sure, Ben or Danny, if you're familiar with the dropout method in neural networks. If not, I can kind of ask the question more generally. The question was, what are the ramifications of a company such as Google patenting a key part of a neural network? The example that's given is the dropout method. That's now widely used in almost all machine learning models.
So I'd have to study the patent specifically to answer that question fully. But I guess what I would say is there are examples in all innovations of what I would call standard essential patents. And it's no different than arguing, are we allowed to patent sort of telecommunication standards that might run the next innovation for 5G, cellular communication? And of course, the answer has been yes. There are these patents that are allowed to exist. In fact, in many arguable cases, fundamental for these innovations to proliferate. But what is a sort of kind of hand-in-hand concept with a standard essential patent is RAND or FRAND licensing, free non-discriminatory licensing, so that anyone that wishes to use this essential patent has the ability to do so, and so that the field is not otherwise thwarted in advancing. And I suspect Google patenting sort of a key aspect of machine learning is likely kind of thinking along those lines of being a standard patent that is perhaps going to be non-discriminatory license to any and all.
But Dan, under those circumstances, the user, the creator of the AI product would likely have to pay some sort of fee to Google in order to use it.
That's right. Just like any other patent, if you find yourself on the wrong end of the claims of that patent, you need to make sure you are licensed to prevent against claims of infringement. But this is the FRAND licensing concept where you would pay a sort of fee that is hopefully appropriately set, so that you can include your innovation in your product line, or maybe even come up with improvements that get pooled, et cetera, et cetera.
Great.
And I don't know enough about the dropout method to know this, and I absolutely would never encourage infringement of known patents, but it might be an interesting question about the dropout method as to whether that method is discoverable when looking at an AI product, or whether there might be other methods of accomplishing the same thing that that wouldn't infringe on the dropout patents. And so it could be sort of to that point, it would be in Google's interest, if it's really not discoverable, it would be in Google's interest to make a FRAND license at very reasonable cost available, so that it's easier for a company who wants to build a product based on the dropout method to get a FRAND license from Google at reasonable cost, rather than hoping Google will not go through the discovery process and accuse them of infringement and potentially suffer triple damages. So there's as we've said, there's an interesting aspect of all of these AI implementations as to what extent is it a black box, and to what extent can we know by looking at the system how it's implemented or what its internal details are.
It's 3. There's one more question that I think it's short and I think it would be fun to answer. So first piece is a statistical question. I'm not sure if any of us know this answer. I don't, but how many patents on AI does MIT have? And how can participants find patents that MIT has filed?
So I don't know the number of patents that we have that are considered AI quantitatively. I might have a good guess, and we certainly have the ability to kind of query our database to get close, but we don't necessarily find those exercises all that particularly useful. But to the second part of the question, how would you be able to explore those patents? This is where we have certain tools. We have a website that has our patents available for perusing. Not all patents are currently listed on it, but many of them are. And anything that you might wish to further explore, our standard answer is please, email or call or set up a conversation with one of the many licensing officers or associates in the office, so that we better understand the reason for the inquiry. Like, I'd like to start a company and I'm looking for innovations in this particular field, versus, I'm doing a research project and I'd like to know how many patents filed in the last 10 years have to do with X or Y. we would be able to kind of help with those inquiries once we understood the nature of them. But generally speaking, a lot of our information is available for perusing online and various other databases to pull it. But we always encourage and welcome, whether you're in the MIT community or whether you're outside the MIT community, but hoping to potentially commercialize one of our innovations, to sit down and have a conversation with us, and we'll make sure we direct you in the appropriate way.
Thank you, Ben and Danny. And thanks for everyone who attended the session today. I just posted a link in the chat. There are other IAP sessions hosted by the Technology Licensing Office. So check those out, and we hope to see you again at another session.